gentlemen, welcome back to another What If video. Today's topic is what if an employee disputes the existence of a rule in the workplace? Now, to set the scene, let's imagine we are in a disciplinary hearing and the employee pleads not guilty on the basis that he or she was not aware of the rule which was or has been allegedly breached. So, in today's video, I want to unpack the importance of clear and known rules. As a point of departure, the key difference between misconduct and incapacity lies in the fact that misconduct involves the breaking of rules applicable to the workplace in either an intentional or negligent manner. In other words, the employee breaks a rule in circumstances where he or she could comply, but he or she refused or failed to do so. In the case of incapacity, on the other hand, one is dealing with an employee who is unable to do what is expected. Most employers, most of you, are probably aware that the determination of whether an employee is guilty of misconduct depends on whether or not the following questions can be answered affirmatively. So there's five questions that we want to ask and we need to answer them in the affirmative. Number one, whether the rule that has allegedly been broken in fact exists. That's relevant to our discussion today. Number two, whether the rule or whether the employee was aware of the rule or the rule was so well known or obvious that the employee ought to have known about it. And number three, whether the rule has been applied consistently. Number four, whether the rule is valid or reasonable. And finally, probably most importantly, whether the rule has been broken by the employee, either deliberately or negligently. In our discussion, we want to talk about the existence of the rule, the knowledge of the rule, and the validity or reasonableness of the rule. We also know that over and above these five questions that we need to answer in the affirmative, if an employee is dismissed, the dismissal must be an appropriate sanction to the breach of the rule in terms of when we talk about sanction. But one question that we have is, what if the rule is not written in your disciplinary code? Can we still take disciplinary action? Now, we need to take note that the rules may come from a number of sources. For example, the employee's contract, an agreement between the employer and the trade union, even legislation, for example, health and safety rules, etc. It may also be a rule that the employer introduced unilaterally, your operating procedures, or even a disciplinary code, or it may even be found in common law. Now, in terms of common law, in essence, it includes all legal rules not found in legislation and covers things such as an employee's duty to obey lawful instructions, the duty of good faith and honesty, the duty to cooperate with the employer, as well as the duty to do the job with reasonable care and skill. Now, while there are certain rules that are fairly obvious and strictly speaking need not even be mentioned in the disciplinary code, for example, the prohibition against theft or assault or absence without leave, it is good practice to include all rules applicable to a workplace in a document of some kind. It doesn't matter what you call the document, whether you call it a disciplinary code, rules of conduct, or something similar. The important thing is that the rules should be documented to avoid any uncertainty regarding the existence thereof. In addition, supervisors and line managers should ensure that the rules are made known to staff, for example, during induction or even team meetings. This is especially important for those rules that might not be generally known because they are peculiar to a particular work environment or peculiar to a particular job. For example, if we look at the food processing industry, clean hands are critical, but new employees might not know this when they first start out. The more obscure the rule, the greater the need for employees to be informed about it. Since the decision of the Constitutional Court in the Duma versus Rustenburg Platinum Mine, it has become essential for employers who have dismissed someone for transgressing a rule to prove to an arbitrator that the rule in question is valid or reasonable. Dismissing someone for theft or fraud is unlikely to raise eyebrows, but outside of these, the employer will have to provide some evidence at arbitration that the dismissal was an appropriate response to the breach of the rule. Take, for example, fighting in the workplace. Not all instances of fighting will justify dismissal, but if the employer can prove, for example, that given the nature of its operation, fighting creates a serious safety risk and that it has informed employees that it would take a very hard stance or line if people engaged in fighting, it would be able to convince an arbitrator that dismissal of those involved in the fight was appropriate. Obviously, evidence that one party provoked the fight while the other was merely defending him or herself will have to be considered too. The point, however, is that employers must not assume that arbitrators will necessarily know why a particular rule is viewed in a serious light. It is imperative that documentary or verbal evidence should be provided at arbitration to substantiate the claim. Merely relying on the fact that one's disciplinary code says that dismissal will follow may not be sufficient. And this does not only apply to CCMA or bargaining council cases, it applies to your internal disciplinary hearings as well. What we have discussed is what your initiator in your internal disciplinary hearing must also prove to the chairperson. Ladies and gentlemen, that then brings us to the end of this video. Thank you for watching, and as always, should you require any assistance in regards to the review or drafting of your disciplinary code or your disciplinary policy or any other policy for that matter, please do not hesitate to contact us. Until next time, bye bye.